payments of child support, and that's why I commend this bill to the House. Thank you.
Jacinda Ardern.
Thank you, Mr Speaker. I first of all, before I begin, just want to put on record that I think it's unfair and perhaps misleading of the Chair of the Select Committee, knowing full well that at the time that this bill was discussed at Select Committee, Labor had a different revenue spokesperson than they have now. And that spokesperson subbed in and contributed significantly to every debate and discussion on this bill. And now we have a different spokesperson. And I could talk at great length about what happens in reshuffles in government ranks, which Mr Lottinger might want me to reflect on, because not everyone is served well in such reshuffles, but I won't. But I think it's unfair of the Chair to try and claim that a member doesn't have the right to speak on a bill when it is within their remit, regardless of when they took it on. And I have to also point out, Mr Speaker, that I was a member of the Select Committee that considered this bill, and yet I would struggle to suggest to the House the origin of how we came to some parts of this formula, because even now I continue to question whether it's the right thing to do. So you wouldn't have heard that member, the Chair, stand up and give the origin. You didn't actually even hear him explain the formula. In fact, I'm yet to hear any National Party member explain the child support formula in this House. And the reason for that, and I will come back to this, is because it is extremely complicated. Now, some of the members in this House did traverse the intricacies of the formula during the earlier parts of this debate. I was one of them, so I won't go through that again, but I will highlight how if it is that complicated, it has the potential to give rise to issues further down the track. Actually, Mr Speaker, just today I flagged on social media that this bill was going to be debated, and someone said to me, "Can you explain to me how the new formula will work?" And I did point her to the first reading speeches. I'm not sure that that was the right thing necessarily to do. But it does demonstrate something quite key. What I can say is not included in this bill, and this is an issue that, despite Mr Lottinger talking about the fact that this wasn't a bill that was meant to be about preserving child welfare, it's not unusual in international jurisdictions to embed basic principles around the paramountcy principle, the importance of child welfare, into any law that has some kind of jurisdiction over family court matters, and things like child support payments you could legitimately put under that umbrella. So it's not fair to paint this notion as fanciful. It's been used in other jurisdictions. And all that we asked, just to be clear, Mr Speaker, was that we put a specific provision in the bill which referred to the well-being of the child. In fact, even the Children's Commissioner stated quite clearly, gave a suggestion that we add a new section 4A that, quote, to affirm the right of children to be maintained by their parents in the promotion of their ongoing well-being and healthy development following parental separation, and a new section 4L to require that in all decisions and actions made under the Act, the welfare and best interests of the child shall be the paramount consideration. That is the notion of the paramountcy principle. Now, if some member of that side of the House would like to explain to me how that is going to completely undermine what a child support bill is intended to do, I would really like to hear that. Because for what purpose does it exist if it is not to ensure the ongoing financial support and obligations and responsibilities are met by non-custodial parents? And if that's not about the child, what is that about? Now, the fact that when we raised this in Select Committee and had advice given to us by those involved in the drafting that it potentially could undermine what the bill was trying to do, that suggested to me that perhaps we'd started from the wrong starting point. So that's a point that I think it's only fair that we make. I want to traverse some of the other significant issues that were raised during the process of formulating this bill and of it being in front of Select Committee. One was ensuring payments are made. And look, everyone, I would wager, Mr Speaker, everyone in this House wants to make sure that we encourage and assert that child support payments must be made by non-custodial parents, or those who have shared custody, if you will. It is an obligation that I don't think anyone here would dispute. And if we can use the system to encourage and ensure we remove the barriers to that obligation being met, then that's a good thing. Now, that means that we had to consider whether or not reducing the backlog of penalty payments was the right thing to do. Now, on this side of the House, we were firmly of the view that it was. That actually these penalty payments weren't going to the child, they were penalty payments incurred to the Crown, and that if they stood in the way of a child receiving future payments, then we should think about whether or not there were ways to strike the balance between fairness but ensure an ongoing uptake of someone's responsibilities. Judith Collins, it's fair to note, has not always been of that view. In fact, has been quite strident in her view that we should not have any kind of write-off of back payments. It's good to see the government, though, has taken a more open mind on this over time. But what I am upset that wasn't considered or even discussed or a view even put forward by government members was just some response to what the Expert Advisory Committee on Child Poverty has proposed, and that is around child support pass-on. Now, we don't know what side of that argument the government would have come down on, and I'm not asserting here that they should have taken one position or the other. But I would have thought that at the time we were discussing child support and the general principle that the state, and many people will not be aware of this, Mr. Speaker, that where a parent who might have primary care responsibilities for a child, where that parent is in receipt of government support, for instance, is on the DPB, they will not receive any form of child support, even if their non-custodial parent is paying that child support. It will be recouped by the Crown. So the notion of pass-on is simply the idea that no longer do you have the government standing in the middle taking in those payments, but instead those payments go directly to the child. Now, the government may have a particular view on that, Mr. Speaker, but we simply do not know. And yet when the Children's Commissioner is standing up there and saying there is merit to this, and there is merit to this because it encourages payment, it encourages parents, instead of just saying, I'm not going to bother paying because it's just going to the Crown, they know that the only person who will miss out is the child. I would have liked to have heard the government's view on that. No matter what it was, I think that would have been the time for them to express that view, particularly given the international evidence that exists. But when it comes to penalty payments, I'm also disappointed that there was very little discussion and movement around the idea of to what degree we are pursuing payments when they are not made. Now, in other jurisdictions, you'll often see a government will come in and make a payment themselves and then pursue the person in question who's meant to have made the payment, so that no one misses out from the fact that they haven't shown responsibility. Now, that's what happens in other countries, not in our own, Mr. Speaker. But when I have cases coming across my desk where, for instance, a non-custodial parent is living in Australia, hasn't been paying their child support, IRD hasn't been able to track them and ensure they do, and we find out that they're coming into New Zealand and IRD sit on their hands and do nothing, why are we not pursuing that non-paying parent in the same way we would with a fine at the border? Surely not paying for the upkeep and the care of your own child should be pursued with as much rigour as, for instance, a fine by the Crown. Mr. Speaker, there are many other issues that I could have traversed. I hope my colleagues will pick up the complexity issue, the fact that that's borne out by the fact there will be a 15% increase in the need of staff time to spend on this issue. There will be a $91 million operating cost and a contingency of $28 million, and there is a fear that the IRD system might actually fall over under the weight of these changes, and that is something for everyone in this House to be concerned about. This is not just about child support, this is our ability to administer our tax system in New Zealand. But the one thing I want to finish on is the impact on women. The threshold through this formula change, where the amount that a parent who is the primary caregiver has the amount they receive discounted, starts as soon as a non-custodial parent picks up 28% of the care. That does not mean that they pick up 28% of the cost. That does not mean that they have 28% of their life impacted in terms of their ability to take on full-time employment. And yet that is the point at which their child support starts to decrease. This will impact the most on women. We felt like their voice was not heard nearly strongly enough, and I feel disappointed and let down by the amount we heard from the Minister of Women's Affairs on this issue. Mr. Speaker, because of the children, because of the impact, we believe the unfair impact on women, Labour does not support this bill.
Materia Ture.
Thank you, Mr. Speaker. Similar to my colleague from the Labour Party, the Greens are very concerned about this